A very good evening, ladies and gentlemen. Today we begin our session on the epidemic, the disaster management and related issues. Now, we are currently embroiled in a situation of an unprecedented, what we may call pandemic the world over. Now, today's discussion, we will have to keep it a bit within the time constraints. So, although I was thinking of discussing several issues encompassing the legal and policy aspects, we will perhaps cover them, and at the end of it I will also talk of citizens' rights as to whether in this calamity and in this situation we as citizens have any to what extent are our rights affected. Now, just to give a very brief historical background, if you look at it, epidemics have affected mankind since ages. Epidemics we've seen in the Roman times, we've seen in ancient history. Some say even during the Egyptian times they were there. We've heard of the Black Deaths, the horrible plagues, and then threats to life all over history. It remains to be seen as to whether mankind has lost more lives in wars than in diseases. We've heard of Spanish flu. Interestingly, Spanish flu did not originate from Spain or had nothing to do with Spain. At that point of time, we were just nearing the end of the First World War in 1918. So the Spanish flu essentially had to do with because Spain was a free economy, and that's why you had it being named a free press in that manner. So you had a lot of it being attributed to Spain. So now, if you look at the 20th century, we've had possibly huge loss of lives. You had the two world wars, which scorched possibly generations. We've seen Stalin, we've seen Mao, we've seen Pol Pot. I mean, just to name a few. And then we've also seen the Spanish flu. But prior to that, just to go back, rewind a bit, Calcutta in British India was affected by plagues a lot. And when we say plagues, there are the several records, including in the Bengal Medical Gazette, which spoke of terrible plagues in India, especially affecting Calcutta. Then, in the backdrop of one of these plagues, you had the Epidemic Diseases Act being promulgated. A very old British era law, which perhaps has come to our aid today. The old law has state governments have come up with regulations under that. We'll be discussing those. But prior to that, mankind has seen several epidemics. We've known this is being called a pandemic. So I will not get into the medical aspects of it. I will not get into how great an economy India will become, or China will become, or the IMF projections. That we can keep for some other session. But perhaps I will be more interested in addressing all of you on the issues of the legal aspects as well as the aspects of policy interventions. Now, a very important consideration arises here. I will also address people on whether in these times making Facebook posts or writing in your WhatsApp groups will make you responsible or liable. Now, we've been seeing, especially in West Bengal, I've come across instances where people have really been slapped with criminal cases for writing on Facebook or in their, perhaps primarily Facebook, not WhatsApp groups. It's not come to my notice, for writing in these forums regarding the inadequacies and the defects in the fight against this pandemic. Now, issues are twofold. One is the issues and the compulsion on the part of the government to address this threat, to address this issue. And secondly, the other aspect of the citizens' rights. Now, citizens' rights, I will perhaps cover the issues of, I will endeavor to cover issues of right to health, right to livelihood, and the aspects of freedom of the press and also of freedom of speech and expression. Now, primarily I will think India is the forum, so we'll stick to English by and large. Of course, wouldn't mind slipping into a bit of a vernacular once in a while, but that apart, now perhaps let's just get down to the basics. There are twofold laws which the governments, the central government and the state governments are addressing, are the issue with. Primarily, so today's talk, there's been a bit of a query. Today's talk is on the epidemic and disaster management and the current situation. So I will, as I said, I'll primarily stick to the legal and policy aspects. Now, to begin with, primarily the laws is the old British era law of the Disaster Management Act. The Epidemic Diseases Act of 1897. First, let's discuss that law. The Epidemic Diseases Act is a very small law. India perhaps has the largest number of laws in the world. So the Epidemic Diseases Act being a very small piece of legislation, primarily a lot of power and authority. Under that act, I'll just get into a bit of the boring specifics, then we'll come to perhaps what can be. But these issues are important in these times. Now, power to make regulations, power to take special measures, these have all been encompassed within the sweep of the Epidemic Diseases Act of 1897. Under this law, we have seen the government of Delhi has come up with the COVID-19 regulations. We've also seen the state of West Bengal coming up with COVID-19 regulations. Now, we will also see the source and authority of powers under these laws. Whether this lockdown, whether this quarantine, whether these isolations at all have the sanction of the law or not. And whether the sanction of the law we can try and find out through the Epidemic Diseases Act or the Disaster Management Act. Now, under the Epidemic Diseases Act, the state of West Bengal, will be primarily discussing that, has come up with regulations. Now, what is the power of the state government? The power of the state government is, if they see that the ordinary provisions of the law are not adequate enough, or the ordinary provisions of the law cannot help us in dealing with the issue or the epidemic at hand, in that case, and if it is necessary to prevent the outbreak of the disease, in that case, they will be authorized to make such regulations and measures as may be provided in the law, including, say, looking at persons traveling by railway or otherwise. Now, this just gives the power to frame regulations. We will have to keep in mind that this law is primarily a pre-constitution law. Now, as per the Constitution of India, we've been given certain rights. Rights in India can be classified, say, legal rights, then you can have constitutional rights, and then the fundamental rights. Fundamental rights, you can place them at the highest pedestal. What are fundamental rights? We will be discussing a bit more on that today, depending on the time. But fundamental rights, in the current scenario, what we can apply is the right to health, right to healthcare, right within the broader framework of the right to life. Now, these rights cannot be snatched away, even in an emergency. Say, for example, well, we'll come to that example later. I'll give a constitutional provision. Now, that is the provision of right to life, freedom of speech and expression. That also falls within the fundamental rights. Then, freedom to move freely throughout the territory of India. That also falls within the broader framework of fundamental rights. So, whether this pre-constitutional law of 1897 can take away our fundamental rights, which as citizens of India, we've been given in terms of the constitution which we adopted upon the independence of the country, or whether we can have such sweeping powers within the broader framework of the Epidemic Diseases Act. Now, interestingly, Epidemic Diseases Act does not talk of such rules or regulations being placed before the State Assembly. Do not talk of these rules or regulations being placed before the Parliament of India. So therefore, we do not know as to whether such sweeping regulations and notifications can take away any fundamental right, any legal right, leave alone fundamental rights. So these are the broader aspects of the issue. Now, the central government has also been given some power and authority, which would relate to ships and vessels and the ports. Now, I will also give the American position a bit, whereby we can, discuss these aspects of whether the United States is better equipped through a better legal framework or a better policy issue, or through better policies. Now, in India, we do not have a law on public health. In India, we do not have an overarching law which will be applicable in these kinds of situations and to these current times. We are having to fall back on the 1897 law. Now, if you look at it, the lockdown, the central government is not making use of the Epidemic Diseases Act of 1897. Why? Because the central government has not been given such overarching powers as they would likely want to exercise under the Epidemic Diseases Act. Those powers the central government is taking from the Disaster Management Act. Now, just going, prior to the Disaster Management Law, we can quickly discuss the West Bengal position. Now, the West Bengal position is such. West Bengal has come up with the West Bengal Epidemic Disease COVID-19 regulations of 2020. Just to give a small historical bit, the last time we had a regulation under the Epidemic Diseases Act of 1897 was way back in 1900, when you had the Great Plagues. The plague regulations were made for the city of Calcutta primarily. So after that, I'm not aware of any other place where we have or any other regulation so where these regulations have been framed pursuant to the 1897 law, the old British era law. So after straight 120 years, we are finding these laws to be quite essential. So therefore, for all those votaries of thought processes against the constitution, against British era laws, I would say we still have to think a bit before we can really say they should be fit for the dustbin. Now, coming back to the West Bengal regulations, West Bengal regulations primarily gives an authorized person, so which is the director of the health services, the director of medical education in the state level. At the district level, we have the district magistrate, chief medical officer of health, SDO, and block medical officer in the district. Now, as per the regulations, we will see in Bengal, especially for people who are thinking as to what is the responsibility of the government, whether testing is not happening enough in Bengal. The regulations say that all hospitals would have provisions for screening of suspected cases of COVID-19. Now, they also place certain mandate upon people who have traveled or have been in contact with people who've traveled to countries where COVID-19 is there, or have been in contact with people where COVID-19 is, who's tested positive for COVID-19. It gives a bit of overarching powers. Why? Because now the sealing of the geographical area power is there, entry and exit of population. So essentially, if you look at it, certain fundamental rights, certain other rights are being affected through these regulations. We will also have to see and think, these desperate times call for desperate measures, but at the same point of time, we should have measures that are legal. We should have measures that pass the test of constitutionality and also of judicial, legislative due process. So coming to it, closure of schools, offices, banning of public gatherings, hospital isolation of the suspected cases, and containment centers designation. So all of these powers have been given to the authorized persons, and the district administration has been given overarching powers under the Bengal regulations. You also have the Delhi regulations of COVID-19. I mean, a bit theoretical stuff we are discussing, but perhaps, we need to preface our understanding of the issue at hand with a bit of these theoretical aspects. Now, next comes the new law under which you have the National Disaster Management Authority coming up with the lockdown order of 24th March 2020, which had been extended further. So that comes under the Disaster Management Act of 2005. Now, the Disaster Management Act is a central law, but perhaps if you look at it, disaster management law did not entirely envisage dealing with these kind of public health emergencies. Disaster management law perhaps could have been helpful. In fact, even the courts had scolded the governments of applying the disaster management law, say for example in the case of flash floods in Uttarakhand, cloudburst case, where a lot of people died. You've had the earthquakes, including in Kashmir. So it's more to do with these kind of disasters rather than dealing with these kind of public health emergencies. Now, disaster management law came into force in 2006. Then you've had in the disaster, how did they approach disaster under the disaster management law? What is it? Primarily a catastrophe, mishap, calamity, grave occurrence, natural or man-made causes, which results in substantial loss of life or human suffering. So that's how disaster has been understood. So which includes man-made as well as natural causes. I don't know, the COVID-19 pandemic could perhaps be told to be a man-made cause or a natural cause. I don't know whether you blame the bat or pangolin or perhaps the Chinese government. We don't know till then. The jury is still out on that. I mean, I'll just rewind a bit. We'll go to, there was a very interesting ordinance, Public Health Emergency Provisions Ordinance of 1944. This was promulgated by the Governor General of India in Council. You know, 1944, if you look at it, you've had the Great Bengal Famine. Churchill's been blamed. We've seen books and writings on that. In the Second World War, we could have, couldn't have looked at a better calamity than the Bengal Famine. Billions of people lost their lives. And in fact, even, we've heard stories of people would be roaming from street to street and say, Baba Fandao, Ma Fandao. So, they were not even interested in the rice. They would be, happy with whatever little morsel of food we could give them. So that was so devastating. I mean, older people still remember it. So now, interestingly, this law provided the Ordinance of 1944, a very interesting ordinance. There are some ordinances, say the Criminal Ordinance Act Ordinance, a pre-constitutional era ordinance that's still in force. Now, this is a very interesting piece of ordinance which allows the government to take control of a local authority if they see the local authority is not performing its functions. Now, local authority not performing its functions, the government which was given the power to take it was the state government, which is the provincial government. Now, interestingly, we've had the legislative springtime cleaning. The Parliament of India did it. Pursuant to a Law Commission of India report, you had this very interesting ordinance being repealed and told that it's never been applied, so it's fit and proper that this ordinance is repealed. So you had the Repealing and Amending Act of 2017 with effect from January 2018, when this very interesting ordinance was repealed. So which is the very interesting aspect is, it specifically talked of a public health emergency. So therefore, the 1944 ordinance issued by the Governor General, Public Health Emergency Provisions Ordinance of 1944. Say for example, this did not give powers to the central government. This gave powers to the state government. Why? Because the state governments were told that in case a local authorities, say for example a municipality or a panchayat is not performing its functions, under that ordinance it could have been, the powers and functions could have been taken. But perhaps that's no more in the statute books, so we can't dwell upon it anymore, we can't take advantage of it, but maybe we are 2 years a bit late. So perhaps if we had waited till 2020, we could have taken advantage. But interestingly, if you look at it, under the Constitution, health, as we've all heard, is a state subject. What does that mean? State subject for the legally uninitiated would mean the state governments are under an obligation to frame laws, to issue executive directions in terms of the powers vested on them in the Constitution. So that means the central government will not have powers. So what did the central government do? Central government invoked its powers under the Disaster Management Act. Now when the central government invoked its powers under the Disaster Management Act, we've seen section 2E, I mean I'll not get into exact provisions, which talks of disaster management. It creates a three-tiered setup which is primarily bureaucratic in nature. You've got the National Disaster Management Authority headed by the Prime Minister of India. You've got the State Disaster Management Authorities headed by the Chief Minister of the state, and then you've got the district ones. So you have a three-tiered structure of disaster management authorities under that law. And in terms of the three-tiered structure, it is felt there's also a disaster response force, fund, then there's also an agency which has been training institute, all of these. So it essentially looks into the disaster preparedness of the country. Now under this law, the central government came up with these lockdown orders. Now central government, the National Executive Committee of the National Disaster Management Authority had been given some powers under which they issued these lockdown orders. Now coming to a larger issue. Say today I will want to get myself tested. Whether I have a right. Now whether the government's got to under an obligation to give me, to protection of public health. What is the obligation of the government? Under the Constitution, you have the right to life. That's almost an inalienable right under Article 21, protected. Now, when you have the government of, when you have the Constitution giving the right to life, Supreme Court, lately in the 90s you can say, or early 90s, from then on you had the position. Supreme Court said that states also has an obligation for providing a right to health in Paramanand Katara. Then Supreme Court subsequently also said you have a right to health care. Then you've got the asbestos cases and all. So now in the legal jurisprudence of the country, right to health care is established. So again, whether the state can say we do not have enough quarantine centers, whether the state can brush its hands off, perhaps no. Even under Article 47, which is not strictly a fundamental right, but nevertheless it gives a direction to the state in which to function, the directive principles of state policy. I'm getting into a bit of legalese, but it's the duty of the state to improve public health. Now the state has a lot of obligations, the citizen has a lot of rights. We are faced with a pandemic. In fact, health is considered to be such an important aspect by the framers of the Constitution of India that you have even the freedom of religion being subjected to public order, morality and health. So for example, if today someone says, no, I want to assemble at, or if the Tablighi Jamaat says we want to assemble at a particular place in Nizamuddin, and they say that we have our fundamental right of religion, perhaps no. Because that freedom of religion is more of a subservient right. A right subservient to the obligation on the part of the state to provide health, ensure the health and healthcare of its citizens. So therefore, this is the pedestal at which health is placed. Now coming to the aspect of, say, the initial question which we posed today, as to whether I have a right to get myself tested, and if I feel that very well I would want to get myself tested. In these cases, we've seen, especially in West Bengal, a committee has been formed where they will decide whether to screen people as to whether their samples are to be sent for testing or not. In these situations, I will say such notification not valid. Such notification could not have been issued if you look at it from the angle of the right to health. Now, coming on to the aspect of the disaster management law. Now, the disaster management law, disaster preparedness, disaster, we've been seeing orders being issued. So the state governments are deriving their authority from the Epidemic Diseases Act of 1897. The central government is deriving its authority from the Disaster Management Act of 2005. Now, you may ask, what is the way out? Perhaps we have no other way out. We've got, this is all that we have as far as the legal and policy structures are concerned. We also have, very interestingly, there are several institutions which are there. In fact, we've got the Center for Disease Control, we've got Medical Central Bureau for Health Intelligence. These institutes are there. This was, in fact, if you look at the reports, very interestingly, the Central Bureau of Health Intelligence, which is a body essentially under the Ministry of Health. It says that more people have died in non-communicable diseases in India than from communicable diseases. Now, non-communicable, why? You've got the issues of cardiac issues, issues of diabetes and other host of other problems. Communicable diseases, they've got in India, if you look at it, communicable diseases are there to some extent, and there has been some policy response. You've got the National Vector Control Program, you've got several other programs, one after the other. But somewhere or somehow we fell short. Why we fell short? A is we were not prepared in terms of a health emergency. The Constitution of India does not provide an emergency to be promulgated in India or in any territory merely due to a health emergency. It does not fall within the 3 articles. So yes, if you ask me, legally speaking, we are not in a state of emergency. Legally speaking, our fundamental rights are protected. Legally speaking, our legal rights are protected. But at the same point of time, we see we are not allowed to step out. We may not have religious gatherings. And we may not be allowed to speak. Or wait, no, we may be allowed to speak. That is something I'll argue today. That all said and done, our freedom of speech and expression cannot be taken away. Our right to life, our right to health, our right to healthcare cannot be taken away. So today, if we go and approach a state body and say that, please get me tested, then they are under an obligation, in my understanding, to get you tested. Irrespective of the screening committees. I may argue that those screening committees are an illegality and then they interfere with the right to health and the right to healthcare. So if you ask me whether that notification of the government of West Bengal may perhaps be valid, the jury is still out, but perhaps it may fall foul of our right to life, right to health and right to healthcare. It also has certain aspects of ethics and other issues that we will not delve into. Now, coming to the aspect of disaster management law, I will not get into the depths of it, but what I will address, we can have other sessions on other issues. What I will try and address is the aspect of whether we can make Facebook posts critiquing the government, whether we can have WhatsApp forwards critiquing the government, whether we can make social media posts, including on Twitter, critiquing the government. These are aspects which I will discuss right away. Where do we get the right to express our opinion? We get the right to express our opinion from the Constitution of India. It's a fundamental right, including even companies have rights of commercial speech. So, this freedom of speech and expression, whether that freedom can be taken away by some law, and whether that freedom the state can interfere with in any manner. I will digress a little bit to discuss a small bit on the American issue. In United States, you've got the National Center for Disease Control. You've got the federal government, which is their central government, that has the powers to stop people from moving, or communicable diseases from moving from one state to another or into the country. But within that state, it's the state governments. So in United States, the power is, it's a complete federation, if you may call it. In fact, even the judiciary is federal there. So United States has a proper response and a better response mechanism compared to our country. There, the Center for Disease Control issues the notifications in United States. Then the federal government also issues notifications from time to time. But essentially for quarantine isolation, you have provisions in the United States Code for that. Now, the US law or legal system is a bit more better equipped. Now, in fact, even for healthcare workers who come back from other countries into the United States, they are sometimes sent on mandatory quarantine, and then there is a lot of objection on it. Now, coming to the aspect of whether these issues of lockdown, these issues of quarantine, one can approach the courts. Say, for example, you don't have any symptoms and the government sends you to a quarantine facility. Do you have a right to approach the courts? In my understanding, you have the right. In my understanding, this order is amenable to judicial review. One can go and approach the courts and say that, very well, I am being sent unnecessarily. And then one can protest against it. And perhaps the courts also will be under an obligation to look into as to whether, in United States, of course, you have that. You have judicial review. In fact, on the grounds of racial profiling, you had one case where a quarantine isolation order was set aside. Now, that apart, coming back to India. Coming back to the graver concern of Facebook posts, social media posts. So, all citizens, we have suddenly have this barrage of information with us. We want to share information. And you've got the traditional media also being substantially sidelined. And then they had to come on social media to spread news and information. You have almost all government departments, almost all statutory bodies which are present on social media and have some degree of social media presence. And almost all political leaders across the spectrum also have a lot of social media presence. So social media is a reality today. Can we do away with that reality? Answer is no. How do we deal with it? Now this right, which comes from the Constitution of India, of the freedom of speech and expression, it is guaranteed in Article 19 of the Constitution of India. And then this freedom perhaps cannot be taken away in the manner it is being taken away these days. All citizens shall have the right to freedom of speech and expression. However, there may be some restrictions placed on it. The sovereignty, integrity of the country, security of the country, friendly relations with foreign states, public order, decency or morality. So here we have substantially issues of public order. Issues of now whether this fundamentally protected right can be taken away. We also have the right to health that can only be taken away in a very rare situation. You have an emergency promulgated. You have a situation where there is a law which satisfies the test of due process, and then one can interfere with the right to life. We are not going into such depths today. So these Facebook posts, I will tell you, in Bengal, I'll relate an incident. A doctor named Dr. Indranil Khan had been detained for 16 long hours. He had been kept at a police investigation center. His mobile phone had been snatched. He had made merely some posts on social media. He had said, Dr. Indranil Khan had posted that one cannot have such inadequate protective gear for our doctors. One cannot have such inadequate PPE, the protective equipment for our frontline health workers. In Bengal, you had the frontline health workers, the doctors, being given raincoats, and the nurses being given biomedical waste plastic. And this is what he had protested. The state government had acknowledged his social media post and had replied that we are taking measures. Yet he was forced to delete that post. and he was kept detained for 16 long hours in the investigation center, and his mobile phone had been snatched away. And sections of provisions of the Indian Penal Code had been slapped on him. 2 non-bailable cases had been slapped on him. Non-bailable provisions of the law. You had section 153A, which deals more with cases of rioting, where you spread hate. However, highlighting the issue of PPE or protective gear for doctors does not amount to spread of hate. Then he had been slapped with section 505, public mischief, and 506, criminal intimidation. So what had happened is a random witch hunt, an arbitrary application of the law. So in these cases, thankfully, the Honorable High Court at Calcutta intervened. In Bengal, we are seeing, I'm sure it will be there in other places too, where people who are discussing this issue are being clamped down upon, and their rights are being interfered with. Whether such interference of rights is valid in the eye of law. Now, coming to this aspect, there are 3 laws which the state governments are making use of. It is the Indian Penal Code of 1860, again a British era old law, which is the the major criminal law of India. Then you have the Disaster Management Act. We'll discuss that provision a bit. And then you have the Information Technology Act. Now, we have seen, our time constraints would not permit us to get into a discussion on the freedom of speech and expression and the and the Information Technology Act, where the Supreme Court had set aside a provision of the Information Technology Act, section 66A, and had held in the case of Shreya Singhal that this is ultra vires the constitution. You cannot take away someone's right in that fashion. Now, our time will not allow us to discuss on those aspects, but coming to this issue was brought up before the Honorable Supreme Court recently in Alok Srivastav in an order of 31st of March 2020. It was highlighted to the Supreme Court that fake news was being circulated in electronic, print and social media. So electronic and print media we may not be so concerned about, but social media, yes, as citizens, as people expressing their opinion, all of us are concerned. Now, whether this fake news can be published in that manner, the Supreme Court spoke of section 54 of the Disaster Management Law. So that essentially does not prevent you from expressing your rights. What the Disaster Management Law proscribes is essentially circulating false alarm or warning as to disaster or the severity or magnitude leading to panic. Now, it cannot be very remote. There has to be a direct nexus with your post and the panic. Now, one provision which is being quite used quite regularly is section 188 of the Indian Penal Code, which essentially deals with disobedience of the order of public servant, which provides for either a 1 month or a 6 month, depending on the severity of the offence, 1 month or 6 months imprisonment and fine. So now, that's not such an extreme law, if I may call it. The Supreme Court, in the decision in Alok Srivastav, said that we expect the media to maintain a strong sense of responsibility and ensure that unverified news capable of causing panic is not disseminated. The government of India was asked to have a daily bulletin. However, the Supreme Court very interestingly and instrumentally stated, we do not intend to interfere with the free discussion about the pandemic, but direct the media to refer to and publish the official version about the developments. Supreme Court is very clear. It would not interfere with the rights to discuss the pandemic. Supreme Court said this. This was the exposition of the law by the Honorable Supreme Court of India. And then Supreme Court also spoke of, this was mainly primarily relating to migrant issues, where you had the Delhi, a lot of migrants had gathered. So, free discussion on the issue is not prohibited. Now, disaster management law does not prevent you from making comments. It only prevents people from causing panic. Now, section 54 of the disaster management law, which again interferes with the rights of social media posts, is essentially for false warning. So false warning, imprisonment for 1 year or with fine. Circulating false alarm or warning as to disaster or severity or magnitude. I'm so sorry. We had just in the middle of it, there were some technical issues, and now, yeah, I'm so sorry. A bit due to some technical issues, we had not been able to, get across. Now, we were on the aspect of the disaster management law. We were on the aspect of the punishment for false warning. Now, what the disaster management law essentially does is it punishes people for false warning. Now, there is nothing which prevents you from making social media posts. Now, with respect to, now here there is some distinction in the law. Distinction, we have had issues of relating to, say, Facebook, issues relating to WhatsApp. Now on Facebook, if you look at it, it is the administrator of a group has some rights and responsibilities. He can decide on the posts to be made. He can decide on whether certain posts go through or not. So I will say there is a bit more responsibility in the case of an administrator in a Facebook group. But as far as an administrator in a WhatsApp group is concerned, this issue has been judicially tested a bit. Now, an administrator in a WhatsApp group had once been prosecuted against for certain so-called defamatory posts by the Delhi High Court, in the Delhi High Court. So Delhi High Court, this was the case of Ashish Bhalla versus Suresh Chaudhary. Delhi High Court said that an WhatsApp group administrator is not responsible and has no liability for the posts made. You will have to look at it from the perspective of the extent of liability. Why? Because it deals with the extent of control which is exercised. In a WhatsApp group, the extent of control is limited. You cannot control what others post in your group. Now, just going back to the Delhi High Court, so essentially Delhi High Court said that WhatsApp group admins are not responsible or liable. And factually also the case, the court held that it is a bit different because there was no defamatory post, so to say. Now, what the law enforcement agencies try and do is that they attack you as WhatsApp group admins as intermediaries. Now, where does the concept of intermediary come? As a WhatsApp group administrator, the intermediary concept comes from the Information Technology Act. It is defined in section 2W. So now, their intermediary is someone in a WhatsApp group. It would be the WhatsApp itself. Because what is an intermediary? One who stores electronic information, one who records it. You don't record it, you don't store it as a WhatsApp group admin. So circulation of some posts on WhatsApp would not essentially, I wanted to clear the air regarding this because there's been a lot of confusion. On WhatsApp, circulating some posts which get circulated in a WhatsApp group, the administrator is not essentially liable. He has limited control and it is not his responsibility to check into what each person is posting. At best, he can add or remove members. And whether within a closed group it amounts to an publication or not, again, we don't know. The jury is still out. However, in an, although not strictly binding, the Delhi High Court decision would be more binding. In a Jharkhand High Court case of Subhash Yadav, very recent one of April 2019, there in an anticipatory bail matter, the Jharkhand High Court said that since he is a group admin, so he has liability, so he cannot be granted anticipatory bail. It does not amount to a statement of law. Rather, the Delhi High Court decision would amount to a statement of law. But nevertheless, courts have sometimes not been persuaded some ways or the other. So essentially, if you look at it, although there is one contra decision which I could find of the Jharkhand High Court. Now, whether a WhatsApp group admin is an intermediary, he is not an intermediary. Is he responsible or liable under the Information Technology Act? I would say no, because under the Information Technology Act, what is prohibited essentially is punishment for publishing or transmitting obscene material in electronic form or for cyber terrorism and other related issues. So this is when someone posts obscene material, one can be made liable. But perhaps the Information Technology Act provisions are not attracted in the instant case, in the instant scenario. So yes, it is always a crime to publish or circulate fake news. But if it amounts to a legitimate criticism of the government, that under no circumstances can amount to fake news. If the governments are doing it, it is rather an illegal act on their part to prosecute people for making and publishing their opinions, however critical of the government that may be. We will have to remember the diktat of the Supreme Court. Supreme Court did not prevent free discussion on the issue of the pandemic, but what the Supreme Court essentially came down upon was publication and circulation of fake news. So mere criticism does not amount to a fake news. Mere criticism does not make your view illegal. It may be unpalatable to the government, but it is not illegal. It cannot be prescribed by law. So even the governments which are taking the aid of the Indian Penal Code of 1860 perhaps are not entitled to take advantage of those provisions, because the provisions which are being applied are essentially do not have anything to do with this or discussion on issues. So if people are critical of the government, yes, if people firsthand see something and they feel that it's enough is not being done, the governments have no right to come down upon the people. In fact, no other law would or can take away your freedom of speech and expression, except for those exceptions which we've said, which also includes public order. So yes, one may not make defamatory statements that can be prescribed under sections 499 and primarily section 500 of the Indian Penal Code. So one may not make false statements, one may not circulate fake news, but legitimate criticism, however unpalatable that may be to the government, that can never be prescribed, and such rights of the individual can never be interfered with. So in case, and also threats are being given to arrest people, threats are being made to people to delete them. So what do you do if you face them? In those I think perhaps we've exhausted a lot of time. I will not take much of your time today, but that we can keep for another discussion. If police people approach you, what can be a response, or how do you, because now it's not possible for all to approach the courts, and why would someone be slapped with a criminal case merely for expressing their opinion? In fact, even the disaster management law only relates to panic, so essentially criticism would not amount to being foul of the Disaster Management Act of 2005, and mere criticism should not allow the government to take away your fundamental right of freedom of speech and expression. So with this, ladies and gentlemen, I'm signing off today, and it's been great to address the entire to address all of you, and it's the first session of the Think India Paschim Banga site on this platform. So hope we can start with this issue of legal and policy aspects in our mind. In the long term, what India needs, India will need in the long term issues of a comprehensive disaster management, a comprehensive public health law with participation of local authorities, with participation of the local populace. The disaster management law is essentially a bureaucratic setup. It is a three-tiered bureaucratic mandated mandate set, in terms of the law. But then they say desperate times call for desperate measures, but it has to be harmonized. Yes, we will have to deal with the disaster. At the same point of time, we will have to maintain citizens' rights, right to health, right to healthcare, freedom of speech and expression. Hope in Bengal today we can be more critical and yet not be afraid of being slapped with criminal cases. Now, there's been some, if y'all want to have any questions on this, of course, I can take up one or two quick questions. But apart from that, perhaps the United States position is a bit better. India would also ideally need a law on bioterrorism. So this is the order of the day. Now, we do not have a comprehensive law on dealing with bioterrorism, which will, instead of creating separate structures, we will need to harmonize with the already existing structures and maybe take them on board and use their capacities and capabilities. So it is essentially creating tens of different kinds of funds would not be the end of it, but empowering agencies, institutions and authorities would be a better initiative. At the end of it, if you ask me, I'm happy the way the government of India has come up with the initiatives, and we desperately wanted these. And then again, the aspect of right to food I did not cover entirely. Right to food, say many people there are things which we hear where people do not have access to food. So in these cases, right to food would essentially mean right to the public distribution system. Perhaps it will be a long stretch if the government will be mandated to provide food to all, although it should be a moral responsibility and an obligation. But perhaps right to food, we will have to stay limited to right to the public distribution system. I sincerely hope and wish that the ration shops are not looted, that the PDS system ration is not stolen and taken away, and stamps of political leaders are made on them. Hopefully we will have a more efficient functioning at the institutional level. With this, ladies and gentlemen, this is me, Loknath Chatterjee. Health, a small question Mr. Pramanik raised. Is it possible for health emergency to be amended into the constitution? Yes, but then that amendment into the constitution will be a very tardy and a long affair, because that will require a lot of assent and a lot of majority, both at the parliament level and at the other level, because you will be essentially taking away rights of states. So, but in cases where the states do not listen to the central government, the states have an obligation under the Constitution of India to act in terms of the directions issued by the central government, and the states also, in case they continue to disobey, perhaps emergency may be imposed on the states. So that's like an extreme possibility in the constitution. So yes, health emergency can be a ground because we have an express emergency called the financial emergency. Although thankfully till now India has not yet invoked the financial emergency. The other emergencies, all of us have heard of it. That is a topic for another discussion, where we had the fateful emergency imposed by the Indira Gandhi. So well, yes, those emergencies are perhaps fateful times for the Indian nation and the country, and perhaps in these times public health emergency is a reality today, and we will all have to deal with it. So yes, we will require better legislative frameworks, better policy aspects, better policy answers, and all of us are accepting that the governments are doing well, that yes, we need to support the governments, but the governments at the same point of time have to act in terms of the law, have to act as per their the obligations vested in them as per the constitution, and cannot overreach their powers. And at the same point of time, all these directions, I feel, are amenable to judicial review. Yet, gentlemen, ladies and gentlemen, please, what to do? We've got to cooperate and maybe find our rights at an appropriate point of time. Thank you so much, ladies and gentlemen, and for sharing your valuable time today. Hope it was a bit boring, I can understand, but what to do, I had to discuss a lot of theoretical aspects. I tried to keep them aside to the extent possible, but then I thought the first session we should start with the legislative and policy frameworks. Thank you so much, ladies and gentlemen.